new determination.
I was in.
And we're continuing our discussion on the fiscal year 2026 budget. Thank you finally for, well, no, I shouldn't thank you for finally coming in because you would have come in earlier if you had asked. But, and I know you're very, very busy, so thank you for coming in. I really appreciate it. It is about time that we dug into the Human Rights Commission. So over to you if you could identify yourself for the record and proceed.
Great, thank you so much. My name is Big Hartman. I'm the Executive Director and General Counsel at the State of Vermont Human Rights Commission. I use they, them pronouns. Thank you so much for having me here today. And I have been looking forward to coming and talking with you all. And I see a lot of new faces here. So I was thinking of kind of giving the committee an overview of what the Human Rights Commission does. I have the budget book available that I can share if we want to get into what that is. Or I can also just like provide you with an overview of our budget and some of the additional needs that I think are not going to be met with the recommended budget.
So and since we have new people, why don't we go around and reintroduce ourselves and the new folks as well. Martin Malone, South Burlington Representative Chair.
Kevin Coates Christie, ranking member.
I think we've met.
I think we've met, but Kenny.
I meant to coach. I meant that.
We still met Kenny.
Angela Arsenault from Williston. Aaron Dolan from Essex Junction.
Oliver from Sheldon.
Legion White from Pittsburgh.
Ian Goodnow from Brattleboro.
Okay.
Zach Harvey from Castleton.
All right. Great.
Thank you.
Thank you so much. You know, feel free to chime in and ask questions and guide me what you want to hear about most. But I did bring, so I'm kind of old school and I like hard copies. If you want hard copies of our annual meeting, our annual report, I've got those for you. So I'll do a few in this direction and a few in that direction.
Yeah, I told you we knew each other because perfect.
I know. I like hard documents. I don't always like us all looking at a screen. Hopefully there's one extra one for me. I just passed them all out.
Yeah, there is.
It's perfect. Okay.
I'll try.
There you go. You're all set. Yeah, so this is our annual report for fiscal year 24. I'll just kind of thumb you through some of the things I'll highlight for you about what's in this report. So on page 4 is an overview of our capacity. We have 7 full-time staff members, including myself. We have 3 staff attorney investigators who conduct the bulk of our work of investigating complaints of discrimination. Are extremely busy all around the clock conducting investigations. We also have a senior counsel. That was the newest position in our office, which we were able to start last year in fiscal year 24. And that individual is handling all of our litigation. We currently, as we sit here today, have 16 cases in which the Human Rights Commission is a plaintiff. We were able to hire a very seasoned civil litigator from DC. Really excited to have him on board, and he's really hit the ground running. We also have a director of policy, education, and outreach, Amanda Garces, who you may be familiar with, who participates in, who basically does all the work that is not related to our complaint investigations. And we have an executive staff assistant. This is the primary admin for the position for the office and has been also the primary position that fields all of the phone calls and inquiries we get on a daily basis. I have seen that position. I've been at the HRC for 3.5 years now. I've seen that position turn over twice already because of the very high volume of cases coming in the door every day and the incredible demands that position has upon it. So this year, after having another person who was very well qualified and dedicated to the work and totally competent, after having her burn out over the summer, I took on a lot of the intake duties that position had been doing. So I've been answering phones and also doing a lot of the intake process that happens at our office since this summer. I have filled the position and that person is doing great onboarding and learning about the intake process, but there's also a significant amount of administrative duties that position needs to be conducting regularly too. We have 5 commissioners of which Coach Christie is our chair. They're appointed by the governor for 5-year terms. They're basically coming in once a month to hear cases and make final determinations on our complaint investigations. So that's kind of an overview of who we are. And as you turn the page into page 5, 6, and 7, you'll see some more information about our jurisdiction. The bulk of our cases, at least half, are fair housing claims. So these are claims that often it's tenants or prospective tenants are bringing when they feel they have been denied housing or denied other fair housing rights on the basis of a legally protected category. The bulk of those cases tend to be centered around discrimination based on disability. A lot of reasonable accommodation requests that get denied, and landlords don't always know what fair housing rules are or how to apply them, or that they even apply to their rentals. So we follow a lot of guidance that HUD provides around how to interpret our fair housing statute, which is mirrored off of federal fair housing law. In our fair housing work, we do have a contract with HUD to conduct fair housing investigations that implicate both state law and federal fair housing law. So about I think it's around 9% of our overall operating budget is federally funded through that HUD contract. We do not know, as we sit here today, whether we can count on that money next year. So far, HUD is not one of the offices that has seen a lot of cuts, but there's certainly concerns about that, and we are seeing some reduction in some of their case acceptances. They are currently closing or refusing to pay any case involving gender identity discrimination. That has just happened in the last couple of weeks. As I'm sure you know, gender identity is a legally protected category expressly in Vermont law, and we will continue to enforce that regardless of what is happening at the federal level. Moving on, go ahead.
Yeah, go ahead.
So just with that one, like, surprising, not surprising, I guess, but so the fact that you're committed to keep doing, so does that mean just gonna take funding from something else, or there's gonna be a gap? And I appreciate the commitment to it being like, gonna make it happen. I'm guessing that plays into your funding as well.
It's a very small portion of the money that we get from HUD is gender identity discrimination cases. They pay us, we get kind of like a base administrative costs for the contract, and then we get paid per case. And so right now we have 2 cases that are dual filed that they're not going to pay us on, according to the latest note in their system. It's not even like they've sent out an official memorandum about this or anything. So for this year, we would see maybe that would result in like a $6,000 reduction, nothing that's going to break the bank or impact our operations.
Just a quick question. You mentioned 6 cases that you're the lead plaintiff on. Is that historically, like typically about how many cases you're operating on, or is it higher than usual, lower than usual?
Great question. We have 16.
Oh, 16,
that I
sorry.
want to be clear on. And we have a page in the annual report about our litigation, which is towards the back, second to last page on page 15. And this is these are the cases that we filed in fiscal year 24. So we've kind of doubled it since then.
Okay.
Historically, we have had maybe 2 or 3, sometimes 4 cases at once. Those would be overseen by the director, but we had a special litigation fund created a few years back that enabled us to contract out for those cases. So we had a private law firm representing the Human Rights Commission. So I would say 3 or 4 active litigation cases at once. And now we've really been able to increase that capacity exponentially. It's probably a little more than is healthy for one lawyer to handle without a paralegal or any administrative support. But we are being very selective about the cases we are choosing to litigate because of their significance. And we're hopeful that we'll end up getting good case law out of these cases. We really don't have that many cases that have gone to court and applied our standards and our statutes. So we are optimistic that having a litigator is going to result in more of that body of law being created.
Thank you.
And we no longer have, we only have 1 case that is still under a private contract. All of the cases that we had in last year that were contracted out, we have now become the lead attorneys on those.
Thank you.
And we actually already have had a good case law out of the Supreme Court and out of the Superior Courts just in the past year in some motion practice that had been going on. So flipping back to page 6 about our jurisdiction. So public accommodations cases make up another large portion of our cases. And I think it's an area of law that folks don't always realize is there. Folks, everyone has a right to be free of discrimination when accessing or using any place of public accommodation. So you can see some examples of what that is on page 6. It's any business that's serving the public, any type of school, including public or private schools, and any local or state government and agency. So this often will cover the police, it will cover state agencies, and it will cover municipality actions as well if there is a concern that they have been discriminating against folks based on the legally protected categories that are listed here. Our most common types of public accommodations complaints involve, honestly, service dogs in public places. Folks with disabilities who have service dogs are actually fairly commonly denied access to certain businesses or other places that they have every right to bring their service animal that is needed for a disability. So we are trying to accept those complaints because it is actually one fairly straightforward area of law. We're mostly interpreting ADA. We're applying the Americans with Disability Act standards under our state law.
Vic, if you wouldn't mind sharing, see, with a lot of the cases we get, so some people might make an assumption, that people are always looking for some big, cash goal at the end of the process. Would you share that story of the service dog that in higher ground and what the complaining party was looking for as the outcome? Because I think it's important for people to realize people, want to see change.
And that's also something that we want to see. So when we do have a case that we find reasonable grounds to believe that discrimination occurred, like in a case involving higher ground from, I want to say 2 years ago, what we want to see is that the problem was not going to happen again, that the denial will not occur, the discrimination will not occur again. And so in that case, the complainant was very happy to see that the business was going to, as part of the settlement agreement, was going to make sure that all of its employees receive training about service dogs. What are the appropriate questions that you're legally permitted to ask? And have ongoing, both putting it in their handbook and then have ongoing training for any of their new employees to ensure that Higher Ground isn't going to accidentally discriminate against folks who have service dogs. That is generally what we see with most complainants, is that they really just want to make sure that this doesn't happen again. They want to have a place to tell their story. They want to have it looked into, and then they want to make sure that it's not going to happen again. And sometimes there's a financial compensation piece to that. And most often, in almost every case we are involved in the negotiations to make sure that there's some kind of training or education or new policy that's going to be put in place so that this doesn't happen again. The third area, one more thing about public accommodations is that one of the biggest new volume of cases that I've been seeing coming in this year in public accommodations involves school harassment. So these are cases that we are seeing students, families complain to us that their child was a victim of most often racial harassment in schools, and that the schools failed to take prompt and appropriate remedial action to stop that harassment. And it happened again and again. And these cases are really heartbreaking and horrible. I'm seeing some patterns of these cases that, where we're talking about a student of color who's probably the only student of color in their class, being subjected to remarks that then, unfortunately, I'm seeing an escalation of the harassment where these kids are not only being subjected to inappropriate remarks based on their race, but then sometimes, too often lately, it's coupled with some kind of physical assault or violence or threats of violence.
I'm doing question.
I did. Just a little more detail on that. I'm curious, is more of it social media related or is it face to face? Or I'm just wondering what you're seeing.
It's a combination. And it's not just social media. It can be text or using the Google
Technology.
platforms that are often used in school to perpetrate that. But there's a lot of face-to-face stuff happening too, especially in those outside of the classroom environment, in the hallway, on the school bus, in recess, in the lunchroom, those areas that are less structured, where there might not be a grown-up right there to hear what's being said. And so we are trying to get ahead of this issue as much as we can with our very limited staff to provide harassment prevention training for schools. We see administrators and educators really want to know what to do, and too often don't realize what they should have done until after a complaint is here in our office and it's been through a very stressful, long, protracted investigative process. We are also seeing cases about gender identity and sexual orientation happening in the schools, as young as kindergarten, as old as college. So it's a really important area of enforcement for us and something that we've identified as a priority. We cannot take all the cases that come through the door for investigation. We simply do not have the capacity. So we do have to be selective about what are the types of cases that we say yes to. And this is an area that we collectively as a staff and as a commission have decided is an area of high importance for us. Also recognizing that these families are not likely to have another means to seek justice unless they come to us, where they can get a neutral investigation. We are not representing these parties. I want to make that really clear. Our attorneys are getting information from both sides, from the school, from whoever the respondent is, as well as the complainant. And then we are also getting information from third parties, conducting interviews of everyone, and gathering that information, giving it an objective look to see whether the law supports a finding of discrimination. So our process is summarized on page 8 of our annual report, beginning with the intake process. And I'm highlighting the intake issue because I think it's an area that has been woefully unsupported in our office. Without the benefit of a full-time intake person, someone whose sole job it is to receive these inquiries from the public and conduct intake meetings and then draft complaints if a case is accepted. That duty has been shared amongst the director and the executive staff assistant. So what's happening now is that intake is taking like 3 to 6 months from someone's initial contact with us to someone actually having a signed complaint. And that is too long for folks to wait to even get in the door here. We're fielding around 100 new inquiries a month. We do not have a full-time person to field those. Sometimes they're brief calls, right? But more often it's someone, you're picking up the phone and someone is launching into a traumatic event that they have been through and they want to know if we can do anything about it. And we take a lot of care and we use trauma-informed responses with these folks and strategies to really try to provide a high level of service for them. But it's very hard to do that without someone full-time available to answer the phones and respond to that inbox. So it is something that we are requesting this year, that we requested through the budgeting process last year. And again, this year, it is not in the governor's recommended. And it is being considered across the hall here in the bill H38. It's one of several positions that I think that our office desperately needs, both to be able to meet our current sort of crisis triage state of the high volume of complaints that have been new coming in the last year. But we are also not prepared for an increase in civil rights complaints or for what is facing us in the years ahead here.
What are your criteria for accepting it?
Great question. So some of the basic threshold criteria is, first, have you made your allegations within 1 year? So we have an administrative rule that says you need to make your allegations to our office within 1 year of the last discriminatory act. And then we want to see that a complaint can allege what we call a prima facie case. So the basic initial allegations that would support a claim. I was denied housing because of my race. That would be like, and having some facts to support that, not just an allegation. And then if they have met those two criteria of being able to show a prima facie case and being timely, then I have to look at bandwidth. Then I have to assess, okay, do we have the staff to conduct an investigation? And I have taken more cases than we have capacity for right now. As we sit here today, I have 15 cases that are not assigned an investigator, and I have another 15 cases that are just waiting for a signature. They're accepted and I just haven't gotten the party's signatures yet, or haven't had a chance to draft their complaints. So all of my staff are full, and those investigations are averaging over a year. We've done everything we could in the past year to streamline our processes. I've been director for about 1.5 years now. We've onboarded a new case management system that is helping us with our data and with our document tracking for each case file. And we have significantly shortened the amount of time that investigations take by simplifying our investigative reports. We used to state every single fact of a case and have a citation at the end of every sentence in our investigative reports. And while those reports are very valuable to the parties, it is a very time-consuming exercise, which would result in one investigative report taking sometimes 2 or 3 months to complete. after the investigation is already done. And I did not feel that that delay was at all acceptable. And as I spoke with other Human Rights Commission directors in other states, I learned that no one else is providing that level of detail in their investigative reports. And it's really just meant to be a summary of why you're making the recommendation of reasonable grounds or no reasonable grounds. So we have really simplified our investigative reports, but without compromising the quality of our investigations. And that has resulted in more cases getting closed in fiscal year 24 and even more now this year in fiscal year 25 that we've been using this simplified report method for about a year now. But still, those improvements and those innovations to our processes are not enough to meet the needs of the folks coming to our office every day. And it's very uncomfortable to be working in a state agency and constantly telling people, I'm sorry, we just aren't able to help you. We just don't have the staff. We just don't have the resources. And I turn people away every single week who have meritorious claims that we are not going to be able to investigate simply because of bandwidth. So this is I feel like a little bit of a broken record because I'm coming into every committee and having to say these things, and I'm making a very substantial request for an increase in our budget and our capacity and staffing in order to meet the needs of these times today, where we're at today. So I will allow you to flip through the data points that are in the pages that remain. And I just want to highlight that we had a 39% increase in the number of new complaints that we accepted in fiscal year 24 as compared to the prior year. And we also had a huge increase in the number of determinations that we had. And that is because we have really improved our processes and streamlined writing our investigative reports. So in fiscal year 23, we had 19 determinations. In fiscal year 24, we got that number up to 33. As we sit here today, I should have done the math before I got here, but I am very confident in telling you we have already had 33 determinations this year in fiscal year 25. We're closing out more cases than ever, but we're getting in more cases than ever, and we cannot keep up. Every month there is more coming in the door than is getting closed. So that's the overview. And I know we're here to talk about budget, so I want to make sure I give us all some time to talk a little bit about our budgetary, what our budget is looking like and what I think it needs to be to meet the needs of our times today. So I have the budget book available. I don't know how much in the weeds folks want to go. What I can tell you is that our operating budget is a little over $1 million. About 10% of that is that HUD money. Just under 100,000 is budgeted for the HUD contract. If HUD funding is going to stop, I'll have to come to BAA for that 100,000, but at least that's all it is. I know there are other agencies that have a lot more federal funds at risk right now. I did submit, so what I want to say about the operating budget currently is that it's almost entirely general fund. 90% of that budget is salaries and benefits. I cannot do anything about that. And because we have so many lawyers, we're on the attorney pay plan. It's just meaning that the salaries are higher than maybe other offices that have only 7 staff. 5 of our staff are attorneys. Then that other 10% that's not salary and benefits are operating expenses that I have no wiggle room on whatsoever. We really don't have, we have $0 for outreach. We have $0 for any kind of public service announcements or, conferences or anything like that. We are really operating bare bones, in my opinion. So I submitted a memo, like a 2.5 pager, that's from me. This is very similar to what I submitted to the governor's office, the administration through the budget process, explaining why we really feel the need to request additional positions. And I'm happy to go through what the positions that we're requesting are in a little more detail. So I've already made reference to an intake specialist, just someone whose full-time job is answering the phone, processing intakes, having intake meetings with people, and drafting complaints. It would be amazing, and I think it's just important for our agency to be able to have someone full-time doing that work. However, if I have a better capacity for intakes, I need to have a better capacity for investigations. Because the more intakes we do, the more cases we have on our docket. So I am requesting 3 new staff attorney investigator positions, which would double our current capacity and enable us to close cases in a more reasonable timeframe. In fiscal year 23, the average age of cases at closure was 650 days. That is way too long for complainants or respondents to know whether the law was violated or not. And then we were able to reduce that number a lot in fiscal year 24. We got that average age of cases at closure down to 474. Great improvement. We're really pleased with that. It is still way too long for folks to wait for justice. And bear in mind, that doesn't even take into account the time they're in intake. I just did an intake for somebody who reached out to our office in August, yesterday. You know, folks are not pleased with how slow our process is. And it's a great weight on the staff. We feel that. We feel terrible that a mother is waiting for us to conduct an investigation while her child is still in school with these same administrators. And we haven't even talked to them. The case has been pending for a year. It's really not acceptable in anyone's view. And it creates, I think, us having to turn away so many cases, and the delays in our cases is really shaking the community's confidence in our office and in our willingness to enforce Vermont's anti-discrimination protections. In addition to the intake and investigative capacity increase that we're requesting, we're also, I think, desperately in need of a communications and outreach coordinator, someone who can get the, host Know Your Rights trainings, who can do our social media, who can put out newsletters and information on a fresh basis about what's going on. And we are fielding questions, all the time about people's rights, and getting invitations to go and do trainings and do Know Your Rights panels with folks. And I just don't have time to do all of those things. And Amanda Garces is over here in the building, trying to keep track of civil rights legislation and all of the other work that needs to be done. We really desperately need more outward-facing community outreach capacity. Another position we're requesting is a paralegal. I don't know another human rights commission that doesn't have a paralegal or 2. The Attorney General's Office Civil Rights Unit has a paralegal. We should absolutely have a paralegal to support our litigator and to support our investigators with some cases that right now we don't have a lot of capacity to process at all, which is cases that talk about discriminatory impact of practices, things that are going to have a lot of data and a lot of documents related to them. These are the things that a paralegal support could provide for us.
So we can see that request is all in H38 as well. I mean, that's laid
Yes.
out there as well as the other memo. Okay.
Yes.
Yeah, I'm looking at that right now. So, okay. All right. Yeah.
I just have a quick question, following up on Representative Christie's question earlier about outcomes. And, I think obviously there's a few different things that come to mind. I think one is obviously justice and accountability for the people for the victims, and obviously accountability for the people perpetrating, these acts of harassment and prejudice. I think 2, and this is a point that you mentioned earlier, Vague, is referring to case law, which I assume is really a really valuable outcome just to help set precedent. And this is what Coach was mentioning, outside of those two those two valuable things, is it monetary settlement that typically victims are compensated with? Like, what are the other valuable outcomes from the work that your team is doing?
Yeah, monetary compensation is the third
Right.
sort of outcome that we see in many cases, but not all of them. Sometimes it's doing the thing, granting the reasonable accommodation. You know, putting in a safety plan. It's doing the thing. That is the outcome.
Yes.
That is most sought for and really is the solution to the problem. But also for folks that have compensable harm, if we were to go through a court process, they would be entitled to pain and suffering, lost wages, other damages, and attorney's fees, and potentially even civil penalties under the statute. And so often it makes sense for parties to resolve a complaint with some monetary payment when that makes sense.
Sure.
And when it can be done, when there's
Right.
money to have, yeah.
Do you have an idea of the average settlement size?
Oh my gosh,
I mean, it
it's a
ranges
huge
between five
range,
years, yeah.
yeah.
I guess on
So,
the top end and bottom end, I guess.
yeah, the bottom end is zero.
Yeah.
There are cases that settle for $0,
Yep.
and I want my learning plan accommodated, you know? We had one case where a housing case where someone was denied what they had asked for a year. He wanted $1 for every day. He got $365, you know, and a promise that that won't happen again, you know? The largest settlement that we've had in the last year, or perhaps ever, is $175,000 for a family that experienced racial discrimination in schools. I mean, we went reasonable grounds on it. It did not go to a court process. It was after we had a determination. And then the parties participated in mediation that I was in. And we all came to that agreement along with a 3-year training plan for that school to work with us to get harassment prevention training in each of the schools of that school district.
Thank you.
So we felt like it was a really fantastic outcome.
Yeah.
I think the more capacity we have, especially to do litigation, the more inclined respondents are to show up at the table with some money and some action, just to what we call public interest relief, to provide public interest relief, something that's going to make us feel like this isn't going to happen again.
Yeah, and education is obviously a huge component of that.
Yeah.
Thank you. That's really helpful context.
Angela, then, Ian.
So I'm wondering if, and again, understanding it probably varies, but do you find that people are coming to the Human Rights Commission as a first step, or, maybe a first legal step, or is it after they've tried a lot of other methods? Yeah, I'm just wondering. That's my question.
Most often it's after they've tried to directly deal with the situation as much as they could. Especially with harassment cases. These are parents who have worked with the school. They've had the meetings with the principal. They've met with the superintendent, you know, it's been an ongoing saga and they don't see another avenue. And also there are folks who generally have very limited means. They often do not have attorneys. They're desperate for legal advice that we do not provide to them. We can tell you what the law says, but we can't tell you what you should do. We don't represent you. Sometimes they're represented by legal aid. Those are almost the only attorneys that I see in our cases that represent complainants. Respondents, on the other hand, usually have lawyers, defense attorneys, and, you know, landlord-tenant lawyers. If they didn't have our office to come to, they really would have no way to find out if what happened to them was wrong or not, or unlawful. Because many things can be wrong, but not necessarily unlawful. Did that address your question?
Yes.
Ian.
I think, and my question is kind of in that same vein, and I think that answered it, but I just want to clarify. Talking about the delay and everything, does your mediation and everything, does that preclude someone from like hiring a lawyer and suing the school, or like like, could they be taking that avenue if they wanted to? Or like, are we trying to encourage, or is it necessary for someone to go through the Human Rights Commission and have a finding made before they move forward with a private civil action if they have a lawyer?
Great question. So for most of our cases, there is no requirement to go through our process to file in court.
Yeah.
And the reality is though that most complainants have absolutely no resources. And there are not very many civil rights attorneys who take these cases. So if they don't come to us, they'll not pursue that. But for employment cases, which I don't think I actually got to, we do have a segment of our cases. Our jurisdiction covers employment discrimination complaints involving state employees. So employment cases that are filed and implicate both state and federal law, you have to go through a complaint process to get that right to sue letter from the federal government for the ability to bring your claim under federal employment law. But state employment law, there's no right to sue letter. You can go straight to court. The school cases are in this special category because we're actually looking at Title 16 with those cases. And the section on harassment requires that parties exhaust all administrative remedies prior to filing in court. We do believe that our office is one way to exhaust an administrative remedy. I don't think it's the only way, but it is an important way. And it's so those families have to show in court even to get through the door that they have exhausted administrative remedies.
And so if I just,
Yeah,
so
go ahead.
that would be another, for at least those two areas, a delay could be really prejudicial if like you started getting so far away from the time of the incident that you could be getting like a statutory limitation issue. If that party wanted to exhaust all of the other options and then did want to take the party to court.
Absolutely.
Yeah.
The other way I think it's prejudicial for the delay is that we lose evidence, we lose witnesses as
Yeah.
time passes.
Yeah.
When I first started at the Human Rights Commission in 2021, I was an investigator. I was assigned cases that were already 3 years old. And I'm talking to people in 2021 about something that happened in 2016 and no one remembers anything. And they can't find their email. They moved out of state. We can't even find some of the people that if we had been able to do that investigation fresh, we would have a much better picture of what happened. Yeah.
Sure.
With the employment law piece, this is connected to something that you mentioned earlier about the Attorney General Civil Rights Division. And I'm sure it's very clear and I just don't know, but so I'm on their page now looking at it, I'm like, oh, there's some of the similar things. How do you work with them? Or is there a clear divide? It's like, okay, so they cover this, we cover this, and both are needed.
Yes, there is a clear divide. So in general, the way I look at it, the Attorney General's office receives is the agency that investigates employment discrimination, except for state employee. Because the Attorney General's office is going to represent the state as the employer, our statute kind of carves out an exception and says cases against the state that involve employment discrimination will be investigated by our office. The only way we're really interacting is referring folks over. So I often get inquiries from folks that have a private employer and I say, here, you should go to the Attorney General Civil Rights Unit. Civil Rights Unit similarly will get a complaint about a state agency. They'll send that to us. But it's so, and I think it's really interesting. We have very different processes that we follow, even though we're both interpreting the same statute, which is the Vermont Fair Employment Practices Act.
Thank you for that.
So, did you cover all the things that you were going to hit on as far as?
One of the things I just wanted to share with you, thank you so much for giving me all this time.
Yeah, no, absolutely. I just
Really appreciate it.
A time check and that.
Yeah, so this year I had a very small amount of money from a HUD grant. And I created this on Canva and got it printed with HUD money. And this is a guide that I'm using every single day. It's on our website. You're welcome to take copies. It's a guide for complainants and respondents to understand our process. I found that we were answering the same questions all the time about how does this work? And people would be partway through a process and be like, what is the commission meeting? And so we created this plain language document to help folks understand the basics of what our process looks like.
Is that also online?
Yes, it's on our homepage.
Okay.
And then I also have my last piece of papers for you, if you want them. This is up to you. We made like a 4-pager for a Human Rights Day event that we did in December. That was and included in that this flyer that is meant to kind of make the case for additional resources and our need for them. So there is some fiscal year 25 data in there. It's a little old now because I wrote it in December, but all I can say is that the number of inquiries we've received has gone up. The number of new complaints we've received has gone up, and the number of people I've turned away has gone up since December. And so as we sit here today, we have 68 cases under investigation. We have 90 people waiting for an answer about whether we can accept their complaint for investigation. And we have 16 cases in litigation. And we're doing all of that on what I consider to be a shoestring budget. And it is resulting in employee turnover, the very severe burnout that staff are experiencing. We have almost turned over our entire staff in just the 3.5 years that I've been here. There's only one person still on staff that was here when I got here. And that is not because people leave and they want different jobs. They leave because it's killing them. It is unhealthy and unsustainable to enforce civil rights in such a meager set of resources. These are folks that are dedicated to the work, but just can't sustain because of health. And because this work really weighs on you, we're talking about trauma. What we're seeing lately in the last year is a real spike in the number of complaints coming our way, significant increase, and a significant increase in the severity. I think hate is on the rise. It's not just accidents that's giving rise to the complaints. Sometimes it is. People don't know the law on service dogs. Okay. But there's also an increase in sort of folks feeling like it's okay to say and do certain things against certain community members. And those folks are coming to us for justice. They're coming to us for validation. They're coming to us for an investigation. And we're just doing what we can. But we can do it a lot better with a really dedicated increase in our capacity.
So have you been presenting, or have you presented across the hall? So I assume that it would be part of their budget memo, whatever they're going to be proposing or advocating on behalf of the Human Rights Commission.
We certainly hope so.
Okay, so I mean, I've reached out to the chair and to find out what that request is, and then I'll put it before this committee as well. But I'm letting them lead on that because it's really within their jurisdiction initially. But I think that, I would like to support what their request is, but they'll put it before this committee once we see that. So
they were supportive of an increase for the budget adjustment that is currently, hopefully, maybe happening. It does look like the Senate side BAA reflects 2 additional positions for this fiscal year, which would enable me to get an intake person on staff right away and another investigator that I would immediately assign a full caseload to. But I don't know whether BAA is going to come out the way it looks on the Senate side. It didn't make it into the House BAA.
Right.
But we're optimistic and we're incredibly grateful for the support that the legislators I've been meeting with have offered already. I had the same presentation on the Senate Judiciary. I've been to both of the appropriations committees twice for BAA and for fiscal year 26. So I'm really grateful for your consideration of that. And feel free to reach out to me if there's any more questions that pop into your mind as the next few weeks and months go by, and anything more you want to talk about. But I'm going on vacation next week. I'm not going to be here.
Somewhere warm.
It is going to be somewhere warm.
Hey.
In the morning, yeah.
That well deserved, I'm sure, so. All
A
right,
little overdue, yeah.
so, this afternoon, folks, we have, sorry, we'll probably be keeping you here a little bit later than the 2 o'clock normal time. It's that time of year. We got 3 Fridays left before crossover.
Yeah.
At 1, we have Jen Pullman and Sarah Robinson to kind of finish their bits. 1:30, we have some people from State's Attorney's Office, ESEA, but they're, I think, a deputy state's attorney, a victim advocate, and a staff person to kind of tell us the challenges they're facing. And possibly at 2 o'clock, we'll have Tim Leaders Dumont and Annie back in to actually tell us about their request, because we didn't quite get there when we had them before, and we'd like to kind of hear that. So just to kind of lay out what the plan is generally, while I have you all here, or mostly. Thank you again.
Thank you.
Thank you so much.
So on Tuesday, just to give you a heads up already, Tuesday, we're going to hopefully hear the final, hopefully, H2, Eric will be presenting that to us. We'll probably get just started on one of the other domestic violence bills, and then we will have discussion of the budget memo and how I'm gonna work that. I haven't quite figured that out, but I'll have something in front of folks on probably by the end of Monday, and we'll discuss it on Tuesday afternoon, see what we're gonna do